Good morning, Dr. Zainal and everyone. We, Group 5, are honoured to present on the topics transfer and transmissions of criminal cases from one court to another under the statutes of CPC and other specific statutes.
First of all, the Code of Criminal Procedure establishes the fair and reasonable transfer of cases from one court to another to preserve the confidence of the public in the judicial system and to uphold a high level of integrity and fairness amongst the members of judiciary. In such a context, there are several provisions of the Criminal Procedure Code and other specific statutes that provides for the transfer of cases from one court to another. For instance, the CPC, the Dangerous Drugs Act, the Firearms Increased Penalties Act, the Courts of Judicature Act and the Subordinate Courts Act are the statutes which includes the provisions that govern the transfer of cases in the country. The transfer of cases can be lateral or vertical. A lateral transfer involves the two courts which have comparable powers but different local jurisdictions. For instance, a lateral transfer occurs when a case is transferred from one magistrate's court to another magistrate court. In contrast, a vertical transfer occurs when a case is transferred from a lower court to a court of higher jurisdiction with different powers but within the same local jurisdiction. For example, the case transferred from a magistrate's court to a sessions court or a high court. Next, in terms of transferring the cases from one court to another court, Section 177 of the CPC empowers the magistrates or the session court judge to transfer a criminal case to a higher court. Per Section 177 of the CPC, it is notable that there are two contexts where the power of magistrates in transferring a case to a superior court may be exercised. The first situation is that the magistrates believe that he might be unable to inflict an adequate sentence to deter the offences. As for the second situations, the transfer of cases can be applied by the public prosecutor, with the prerequisites that the prosecutor would have to satisfy the magistrates in the transferring of the case.
The ground to transfer a cases by High Court is stated under Section 417, Subsection 1 of Criminal Procedure Code. The case can be transferred where a fair trial cannot be held in any lower criminal court. This can be seen in the case of PP and Keng Seng, where the case had been transferred from Session Court to High Court due to the position of President of Session Court who had been appointed as Deputy Public Prosecutor. The transfer of cases by High Court can also be made where the question of law had become unusually complicated. The court had taken a view regarding this matter in the case of PP against Datuk Kee Yong Wee, where it stated for this ground to be worked, the question of law or the cases must become very unusual. Next, paragraph BB contemplates regarding the lateral transfer, where this kind of transfer will usually be made for grounds 3 and 4 of Section 417 Subsection 1 of CPC. Paragraph CC contemplates regarding the vertical transfer, where usually this kind of transfer will be made for grounds 1 and 2 of the same section. In one recent cases, which is the case of public prosecutor against Rosmah binti Mansur, illustrated regarding the unilateral transfer. In this case, the accused object the court order to transfer her case with another accused person to be tried together, saying that the provision in the CJA did not give any jurisdiction to the High Court to try her case. However, it was held by the court that the provision under CJA did not contradict with Section 417 of CPC. Therefore, the High Court has the power to make the transfer happen.
Another type of transfer of case under Section 177 of the CPC is known as transfer of case by the prosecution. This procedure to issue a certificate and transfer a case from the subordinate court to the High Court is governed under Sections 418A and 418B of the CPC. Originally, this section was held to be unconstitutional in the case of public prosecutor against Datuk Yap Peng, as it contravened to Article 121 Clause 1 of the Federal Constitution. This is because the law during that time ruled that the power to transfer a case is a judicial power by the enforceable courts. Prior to this decision, an amendment was made to Article 121 of the Federal Constitution by deleting the word of judicial power, which then gave rise to the existence of Sections 418A and 418B of the Criminal Procedure Code. Next is transfer of case made by the accused application. Governed under Section 417 of the CPC, this application must be supported by an affidavit. It can be best illustrated in the recent corruption case involving Datuk Sri Zahid Amidi, where his defence counsel made an application to transfer his case from the Session Court to the High Court, and the application was granted.
Section 41A of the Dangerous Drugs Act illustrated two types of offences: cases that are triable exclusively by the High Court and cases that are required by the PP to be tried by the High Court. Under the first category, if the accused is charged with drug trafficking under Section 39B of the Dangerous Drug Act, this offence must be tried in the High Court. And Section 39B subsection 3 also specified that a prosecution under this section must not be commenced unless by the approval of the PP. The case of PP vs. Marwan ruled that the court must mandate the transmission once the order is produced. Cases that are not covered by Section 39B of the Dangerous Drugs Act are tried in magistrate or session court but are required by the PP to be transferred to the High Court. In the case of Sarimutu Sinapan vs. PP, it was held that since the case was pending in the session court, it could still be tried in the session court unless it is required by the PP to be transferred to the High Court. Besides, the requisition of the PP is only allowed if the trial has not yet commenced, as shown in the case of PP vs. Muda. As corresponding to Section 41A of the Dangerous Drugs Act, Section 11 of the Firearms Increased Penalties Act relates to offences in the Act where it is required by the public prosecutor to be tried by the High Court. Paragraph 12 of the Schedule to the Courts of Judicature Act grants the High Court the authority to transfer cases to or from the subordinate courts. This can be seen in the case of PP vs. Zuliang Yu. Nonetheless, Section 417 of the CPC does not allow transferring a High Court case down to the subordinate court. The Federal Court in the case of PP vs. Lim Shui Wang ruled that since paragraph 12 of the schedule is subject to other written laws, it confers no authority to transfer cases to a subordinate court. Paragraph 3, subparagraph 2 of the third schedule to the Subordinate Courts Act also grant the subordinate court the authority to transfer a case to a lateral court upon application or on its own motion. This can be referred to the case of Manshur Omar versus Public Prosecutor.
Section 177A subsection 1 of the CPC laid down the general rule that whenever there is a prosecution in respect of an offence which is exclusively triable by the High Court, no such prosecution could be instituted unless with the consent of the public prosecutor. Nevertheless, even if a person of such offence is tendered before a subordinate court, Section 177A subsection 2 of the CPC prescribed that the subordinate court shall, after explaining the charge to the accused, transmit the case to the High Court and cause the accused to appear before the court as soon as may be practicable. Various precedents discuss this matter. For instance, in Teo King Guan vs. PP, whenever a charge of an offence which is triable by the High Court is tendered before a subordinate court, the duties of the magistrate or section court judges is to simply transmit the case to the High Court. It is beyond their jurisdiction to actually question or decide in the legal technical parts of the matter. In short, the only responsibilities of the magistrate or section court judges is to transmit the case without entertaining any application from the accused at that point of time. In summary, the authorities of transferring criminal cases from one court to another is instituted differently. Nevertheless, the power to transfer is a necessary mechanism to ensure the parties are rendered justice treatment. It is right to note that the transfers of criminal cases shall not be confined to the considerations of differences in punitive treatment, but shall also consider whether the complexities of the law in the matter could be properly appreciated by the judge in the ordinary tribal court. In Raja Petra Raja Kamarudin vs. PP, the court urged that it is not proper to have an assumption that whenever a case was transferred, it will automatically come after with a harsher punishment. Instead, the transfer should entitle the matters of the accused to be presided over a more experienced and mature judge. A transfer, in fact, is necessity to protect the rights of the accused and access to a fair hearing. Thank you.